Good afternoon. I'm Marcus Christian with Mayor Brown's Cybersecurity and Data Privacy Practice. I'm joined here today by my colleagues, Laura Hammergren in our Chicago office, and Chris Mixon and Emily Strunk, both in our Washington, D.C. office. Today, we'll be discussing cybersecurity as it applies to medical devices and patient data. In particular, we will cover the following topics: the FDA and medical devices, HIPAA and PHI, key issues regarding those, and trends and best practices for enforcement and investigations. Now, as you know, in the FDA and medical device space, there have been many developments over the recent years. The number of connected things is growing dramatically by leaps and bounds. And in fact, I'm having a little trouble here. By 2020, some experts believe that 200 billion connected things in terms of personal devices, homes, cars, animals, hospitals, and entire cities will be connected. Now, as those opportunities and that connectivity bring to us many benefits, it'll also bring opportunities for threat actors to actually hack them. And we've seen evidence of this in terms of infrastructure, power grid, transportation, in terms of cars and other modes of transportation. We've seen it in healthcare with insulin pumps, infusion pumps, and other devices. And we've seen it certainly in terms of federal agencies being compromised. Now, before we get in depth in our presentation, I want to have a couple small housekeeping announcements. As we go along, first of all, we hope that you will provide questions by using the Q&A panel on the right side of your screen. We'll make every effort to answer questions toward the end of the webinar. However, if we are unable to answer your question during the presentation, we will follow up with you directly after the webinar has ended. And I know some of you are thinking about CLE credit. We will be providing to you an alphanumeric code during the presentation. To receive CLE credit, participants must post this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. With that being said, I'd like to turn this over to my colleague, Chris Mixon, who will talk to you about the FDA and medical devices.
Thanks, Marcus. Good afternoon, everyone. Nice to be with you. My name is Chris Mixon. I'm a partner in the Washington, D.C. office of Mayor Brown, and I specialize in a number of things related to life science and healthcare, in particular FDA medical device issues, and cybersecurity issues related to FDA regulation of medical devices. Just to begin, I'm sure we're all aware of the many cybersecurity threats and issues that have been out there for some time now, and I think the big point here is that healthcare is no exception. Quite to the contrary, actually, it's a bit counterintuitive, but healthcare, through the use of medical devices in healthcare, is actually a significant component of the cybersecurity risks being presented to us today. In the healthcare sector, more so than drugs, more so than biologics, more so than actual physical medical treatment, medical devices are highly vulnerable nowadays. And I think that that's in large part due to the change in the way healthcare is delivered and in the change in the way medical devices are now made and used to deliver healthcare in sort of the new paradigm. It used to be that you'd go into the doctor's office or you'd go to the ER and you'd have an X-ray taken. Someone would print the image off the X-ray. They would take that hard copy image down the hall to someone else who would look at it. They would write some notes by hand in a paper chart, and then they'd put it in a paper file, and that paper file would be kept in the basement at the hospital for a number of years. Now, when you go in to get an X-ray or a CT or an MRI, that device is hooked into the electronic medical record system, and likely maybe hooked in one way or another to the internet, and is thus as vulnerable or more vulnerable than a lot of other devices we use in our everyday lives. A particular example of risks that we're starting to see, problems we're starting to see in the healthcare space and in the medical device space is the ransomware situation. Just like in other areas where you've seen ransomware used, it's a particular problem in the medical device space where a medical device is hooked into a central information system, medical record system at the hospital, then to the insurance company, then to the individual care providers in their own offices. The more we're networked, the more efficient it is for our patients, but then, of course, the more vulnerable we are to issues like cybersecurity. And we're starting to see cases in our practice, and I have an example on the slide here. It is an actual example of it's sort of an amalgamation of a couple of cases we've handled. And I won't go into it in too much detail. It's all there on the slide for you, but suffice it to say that because the medical device using the patient data for research purposes was hooked into the network, it was possible for a third party to hack into the data and hold the information and hold the data hostage in your typical ransomware attack. And on the one hand, patient data is patient data, and it can be recreated, and it doesn't disappear simply because a copy of it is being held in a ransomware attack, but all the work, all the diagnosis, all the treatment decisions, all the connections for research purposes and clinical study purposes can be held hostage, and that can be a significant cost and burden and delay on research, treatment, and delivery of care. So it is a major problem in the medical field these days. Just to drill down on it a little bit more, the types of attacks that you can see on medical devices, we have a slide here. I won't go into it in too much detail, but you can imagine the number of different vulnerabilities there are with medical devices that are connected to a network and are even interoperable with a number of other devices and even devices outside of the strict medical healthcare system, because they're likely connected directly to areas that are involved with peripheral ancillary issues and matters, like even just the payment part of it. The payment part of it going to the insurance companies, going to Blue Cross, or going to CMS, it's all hooked together now. So we'll see all sorts of potential areas of vulnerability, communication ports, the networks themselves, software vulnerabilities. It's an interesting thought at the bottom here, but a patient hacking their own morphine pump, a physician may think that their patient is all safe and good at the methadone clinic 2 days a week. Meanwhile, the patient may be going home and hacking their morphine pump. So there are a lot of, the number and types of threats and potential problems are very wide. And unlike a situation where we're maybe talking about some data for a paper or something like that, in the healthcare situation, in the medical device situation, there is very much the threat of serious injury or death, and of course all of the other issues in the next slide, time and cost burdens on the healthcare system, of course liability, even potentially medical malpractice liability for healthcare providers, loss in confidence in advanced therapies, because in order to have patients to be compliant with physicians' instructions and the use of drugs and devices, there has to be a certain level of patient confidence in the efficacy and safety and the overall reliability of the system, and this could, a cyber attack or the predominance of cyber attacks could really undermine that confidence. I think in particular one of the areas where we might not have seen it come out so much yet, but I think that we probably will see it starting to come out, a really budding area of medical practice is the use of telemedicine, and it's been on the forefront for a while. I think it's coming more and more into the mainstream month by month. We're starting to see provider codes paying for it. We're starting to see CMS allow for it, the majors allow for it. And that's a situation where you have a patient in an examination room, for example, in one state, and maybe they're with their primary healthcare provider, but they need to be seen by an expert, and the experts are few and far between, and so they're literally treated remotely by using video equipment and medical devices to transmit records and even to transmit photographs. For example, if you're in a situation, let's say that you have a mole on your face and you need to be seen by a certain type of dermatologist who specializes in that type of dermatology, you may be and you're in a remote area, you may be treated remotely by telemedicine, and dermatologists use high-resolution photography, actually. They use that to learn the trade first in their residency, and then they actually continue to use that medium for diagnostic purposes, and that's something that could easily be hacked and manipulated, and the examples like that are pretty easy to imagine. Just the point of the next slide, I think, is that FDA has obviously seen these risks, seen cases. We'll get into that a little bit, and just starting to develop a framework for design, development, pre-market approval, and then post-market use of medical devices in ways that minimize, mitigate, or eliminate these cybersecurity risks. Just taking a step back for a moment, I intuitively tend to think of the medical device industry as a relatively small, specialized area. I certainly don't think of it in terms of the massiveness of the automobile industry, for example, or the defense industry, or the aerospace industry. But in truth, FDA-regulated industries, including medical devices and drugs, biologics, and a couple of other things, represent about 30% of the gross domestic product. So if you think of cybersecurity risks in terms of where's the money, where's the value, where do you want to go to maximize the rewards from an attack, and there's an industry that's 30% of the gross domestic product, that is a huge, major industry and a major risk. And I think for some, and certainly for me, that's a bit counterintuitive, but very important to note. As we said, cybersecurity is an issue with medical devices as soon as they're hooked in. And nowadays, like I said, many medical devices are, in fact, hooked in where they weren't 10 years ago. And a big part of that is the push in the last few years for electronic medical records. So I graduated med school in 2005, and back then, we were writing notes. We were doing everything for the patient, keeping charts, everything by hand. And physicians were still using the bad handwriting trick, actually. And nowadays we don't do that. Nowadays, a lot of you go to see your doctor, the physician assistant will be sitting in the room and entering things directly into the electronic medical record system. So even things like your treatment plan, anything pertaining to your medical records, even the dosages of medicine, are potentially at risk to cybersecurity and can be attacked. And you might think that it's not a major problem, but if you have someone who's got a serious chronic disease, let's say advanced diabetes, and they're dependent on a strict regimen of injections and/or oral medications, changing around their medical records could be fatal. And a lot of these chronic diseases are treated in the home, either directly by the patient or in some combination with a home health care visitation. It could have a devastating effect on a large number of people. I think some of you will probably remember Vice President Cheney having his, was it a defibrillator or was it a pacemaker? It was his pacemaker, having it disconnected from the network for just these reasons. And it seemed a little bit overreactionary at the time, but in light of where things have gone, it was actually one of the more prescient things we've seen. So getting to FDA, in terms of FDA's involvement with this issue, FDA does not regulate the practice of medicine. There's a very bright line there. They're not allowed to, and they don't. And they don't regulate other areas as well of healthcare. They don't regulate payment reimbursement. They don't regulate privacy under HIPAA for the most part. FDA is concerned with the regulation of the actual products that are made and used to treat patients, so drugs, biologics, medical devices. FDA regulates medical devices under the statutory definition of medical device, so that's a bright line we'll discuss in a second. A device is either a medical device or it is not, and that's another thing that's not intuitive. We'll discuss that in a minute. But FDA, it's important to keep in mind that FDA regulates medical devices from two main standpoints. One is safety, and the other is effectiveness. So generally speaking, the maker of a medical device must demonstrate to FDA that their device is both safe for its intended use and efficacious for its intended use. And cybersecurity vulnerabilities can affect both, often most likely safety when you think about it, but can certainly affect both. And so that brings FDA squarely into the regulation of cybersecurity vulnerabilities with medical devices. This slide has the actual definition of medical device in the statute. I won't read through it, but it is fairly specific and detailed. The short version of that is that, like the definition of a drug, a medical device is a device that's intended to diagnose, cure, mitigate, treat, or prevent a disease. That's actually a pretty broad definition, and on the ground in the real world, that tends to bring a lot of devices in under the purview of FDA. And a lot of times in the regulatory practice, in our regulatory practice, we spend a lot of our time with our clients, trying to figure out whether their product is or may be a medical device and whether or not we want it to be a medical device. And an ancillary to that is that medical device software related to a medical device can be considered an FDA-regulated medical device if it's a component of or accessory to a medical device. The last point I want to bring out before I turn the presentation over to my colleague, Emily Strunk, is just a little, the next few slides have some background on the history of the development of cybersecurity vulnerability regulation, and specifically that directed to medical devices. I think it's safe to say that it really all came to a head and started a few years ago when there was an executive order issued by President Obama recognizing that there was a problem and directing various departments to start making efforts towards it. Those departments are listed below, including FDA. I'll leave the slides for you to review to take home, but there was a progression of actions by FDA and others. And as recently as last year, FDA only started beginning to issue product-specific safety communications on the cybersecurity issue. So I think it's fair to say that FDA and the cybersecurity issue in medical devices is a recognition of it and addressing it is a relatively recent development, and for that reason, the actions of FDA in the cybersecurity space are actually moving very quickly for FDA, much more quickly than we've seen FDA move in other spaces in the past. The last thing I had alluded to, and then I'll turn this over to Emily, is the threshold issue here for regulatory purposes is whether or not we're dealing with a medical device. If we are, it's an FDA matter, and if not, it's most likely a Consumer Product Safety Commission matter. And like I said, those are threshold issues that we deal with in our practice, and one of the major things we do with our clients to help our clients sift through and prepare for these issues. And with that, I'll turn it over to my colleague, Emily Strunk. Thank you.
Thanks so much, Chris. My name is Emily Strunk, and I'm also an attorney here at Mayer Brown, and I work with Chris on pretty much the same issues. So getting into how FDA is regulating cybersecurity, as Chris mentioned, they're relatively new to the game, but they have, relative to other areas of FDA regulation, been moving at light speed. They have finalized guidance documents relatively quickly, and have, on the enforcement side, we're not seeing heavy action, but that's mostly because I think FDA is giving people a chance to get in the game and catch up and wants to encourage information sharing so that people will be encouraged to share, because as they discuss in the guidance documents, these are, this is critical to developing protections against cyber threats. So they regulate, similar to the way they regulate all medical devices, they regulate the cybersecurity of medical devices through pre-market considerations and also post-market considerations. On the pre-market side is the medical device software proactively designed to prevent cybersecurity vulnerabilities and exploits. And a vulnerability is basically, just to go back to some basic definitions, a vulnerability is how a cyber attacker might attack a piece of software, while the resulting impact is what the attack does. On the post-market side, FDA looks to see whether the post-market compliance program adequately addresses the cybersecurity issues that lead to safety or effectiveness concerns. And although the regulations don't specifically speak to what these risk management strategies might be, FDA has essentially said that they expect this to be a part of the quality systems regulation requirements. So as you're looking at the risks, the health and safety risks of all the devices, that you must also incorporate cybersecurity considerations into those risk assessments. So to get into the pre-market considerations a little bit, you have to look at the product when you're designing it to determine where there might be vulnerabilities, and how you can proactively address those vulnerabilities. This guidance document was meant to supplement two other guidance documents that relate to software both on the off the shelf and software that is contained within, seeing as how software is essentially what provides the direct port for cyber attacks. So those three should be read together. And then as far as the pre-market approach, you want to identify the vulnerabilities and assess the impact of the threats, how that would affect the functionality and the patients, and also look at the likelihood and the risk level, and then determine what mitigation strategies might be most effective in addressing those risks. Sorry, I'm a little behind on my slides. There we go. And if anybody else is like me and frantically writing down and feeling like you missed some slides, don't worry, we will provide them afterwards so that you'll have all the information. So when you've gone through looking at the vulnerabilities and the threats and the risk levels, that what you'll end up with is a residual risk level. And we'll talk about a little bit in post-market considerations. That guidance document goes into that a little bit more, so just tuck that away for the moment. The guidance additionally asks that the cybersecurity functions will be considered and consistent with the NIST framework, which we'll also talk a little bit more about, and then that the document lists required cybersecurity-related documentation standards so that you know what you have to submit related to cybersecurity with your pre-submission. And that's for 510K and PMA, no matter what your pre-submission, your pre-marketing submission documents are, it'll provide those standards. Okay, so that document was finalized, the pre-market document was finalized in 2015, and the post-market document was finalized in 2016, so just a couple of months ago. And there were a few changes from the pre-market or from the draft guidance, but essentially it retained the same framework. That basically cybersecurity risks are continually evolving, and so your cybersecurity post-market risk management plan should also be evolving, continually reassessing risks, and looking at recent vulnerabilities. That's where the information sharing becomes key. As industry shares with each other, different partners can learn from attacks or threatened attacks or vulnerabilities from other industry partners. So this is the list of things that your comprehensive cybersecurity risk management should include. What it basically boils down to is monitoring your cybersecurity information resources, looking at your software continually, and also doing verification and validation on any changes you make to the software to address cybersecurity risks. You want to look at the vulnerabilities and what impacts they might have on your device throughout the life cycle, and you need to educate your team on those and have an intake procedure. And then once you know what those vulnerabilities are, you're going to use threat modeling to clearly define how to maintain the safety and essential performance of your device. So how do you keep the cyber threats from impacting the device's safety and effectiveness? And once you know how it might impact safety and effectiveness, you can look at the severity of patient harm, and through a matrix, you can determine whether or not any vulnerabilities might present a need for just a simple update or patch, or whether it requires further remediation. Those would be the mitigations. And then you would also want to adopt a disclosure policy so that when there are attacks, you can, or vulnerabilities that would still present risks, you can disclose that to the users. And then a deployment strategy for your mitigation, whether that's the patches and updates or something bigger. FDA does not require the NIST framework, but they suggest that you use it. And same, they also do not require information sharing, but if you participate in an information sharing and analysis organization, they will allow you to some enforcement leniency on the reporting requirements. So if you participate in an ISAO and something happens, depending on the severity of it, you will not be required to report that to FDA as long as you report it to the ISAO. And the final guidance actually defines what active participation is for the purposes of enforcement leniency. Additionally, if you report to the ISAO, it's protected from disclosure under FOIA, and there is also an MOU between FDA and two information sharing organizations that will essentially help maintain confidentiality and create an environment that's conducive to industry participating. This is the definition of participation. I'll just leave this here. It's also in the guidance document. Like I mentioned before, participation will basically allow you to not report certain incidents. This is the NIST framework. You want to identify, protect, and detect, and respond and recover. I don't need to read these to you. We'll just go through them quickly. And then this is basically what FDA requires. So you have to define safety and essential performance for each device. Then based on those definitions, identify the vulnerabilities that could compromise either of those things. And then use threat modeling to determine how a cyber attacker might exploit those and what severity of patient harm there might be if they were to do so. The guidance document suggests the matrix, although it acknowledges that you could come to these conclusions in other manners. But it basically wants you to look at a combination of exploitability versus the severity of the patient harm to determine whether or not the risk of patient harm is controlled or uncontrolled. And those two terms will essentially control your reporting requirements. So the ultimate question is there an unacceptable residual risk of patient harm considering the risk mitigations and compensating controls? And those risk mitigations and compensating controls are things that are either built into the device or deployed through a patch to help mitigate and control the risks. Going back to the combinations of the likelihood of exploitability and the severity of patient harm, FDA wants you to look at how much likelihood there is and what the severity of the patient harm would be. And if you have, for example, a high patient harm but a very, very low likelihood that it would ever happen, then it might be a controlled risk. On the flip side, if the patient harm was low, but the exploitability was very, very likely, you might have more of an uncontrolled risk. And actually, I'm going to skip ahead real quick. Oh, sorry. Okay. So reporting is generally not required for vulnerabilities of controlled risks, which, FDA knows that there is risk inherent in every single medical device there is, and some of those are acceptable. You have to balance cybersecurity risks like anything else with the benefits to the patient. But if the risks are acceptable and can generally be remediated by routine updates or security patches, FDA will consider them device enhancements and not actual changes to the medical device that would require, for example, a new 510K. Reporting is generally required for uncontrolled or unacceptable risks to safety and essential performance. So if there's a pretty good risk of patient harm, you're going to have to report and also remediate beyond the routine updates and patches. That the remediation could be a recall, it could be a maintenance that you send out to all your medical devices, but it would not be considered an enhancement, and it would likely require interaction with FDA to carry out. Keep in mind that reporting is always required if the device would be likely to cause or contribute to serious injury or death if the malfunction were to occur, and that's per the MDR regulation. So the guidance document provides some illustrative examples of scenarios for controlled risks and uncontrolled risks that are helpful to walk through. And in addition, the guidance documents also talk about good cyber hygiene, routine device cyber maintenance, continuously monitoring and assessing post-market information, employing risk-based approach to characterizing vulnerabilities and looking at the risk assessments of those vulnerabilities, and then also timely implementation, which, depending on what kind of remediation or necessary action you have, it's 30 to 60 days, but the guidance also emphasizes that it should be as soon as possible. So looking at how this all plays out in the real world, as we've talked about before, there's lots of opportunity. Everything seems to be wired these days, and if devices aren't secure, there's a good potential for an attacker to get through. So far, we're not seeing major vulnerabilities being exploited. There's not, we haven't so far seen anything that has, any cyber attack that has killed a patient. Which is good, but it's not necessarily out of the realm of possibility. As we talked about before, pacemakers, insulin pumps were another recent example of something that the manufacturer had to get in touch with its patients and say that, there was a vulnerability that can lead to hacking that could potentially deliver an overdose of insulin, a fatal overdose of insulin. So hopefully, regulation can keep up and cybersecurity measures from firms can keep up with the hackers. And so now is definitely the opportune time to be looking at this before that happens. And just a summary of what FDA's done, the pre-market and post-market guidance documents are finalized. They've held workshops on the guidance documents to explain them. You can access those online to get a better idea of what FDA is thinking. There's a lot of collaboration going on with nonprofit organizations, including NIST and information sharing organizations. And the enforcement actions, the first one was in May of 2013, and the most recent one we saw was in January of 2017. So we're not seeing them too frequently, but FDA is paying attention. And then, of course, the enforcement discretion if you participate in an ISAO. So basically, the cybersecurity program is still pretty new, but for FDA, it's moving pretty quickly, and I think they are looking to industry for input and advice, even beyond the finalization of the guidance documents. And it remains to be seen sort of how these guidance documents will play out in the real world and whether FDA will continue to refine these guidance documents or issue actual regulations, but I think for the moment they're going to wait and see how these play out. Okay, and I will then turn it over to Marcus.
Thank you, Emily. One of the things that Emily said is, in talking about connected medical devices, is that generally there haven't been any reports of exploits in the real world of hackers hacking connected medical devices, and that's certainly something to take into consideration at this point in time. And what it makes me think of is a fundamental concept in cybersecurity, whether you're talking about medical devices or data, and that is the concept of risk. And most people will tell you who study risk or calculate risk that risk, the formula is risk equals threat times vulnerability times input. And what times impact, rather. What the FDA is doing and what other government agencies are doing is getting manufacturers and others to take a look at vulnerabilities with devices and other information and in other areas to minimize those vulnerabilities. But I'd like to take a little time to speak with you about threats. In the world of connected devices as well as data, understanding threats happens to be an important part of understanding risk and addressing it. So obviously this is the face that no one really wants to see, the words that no one really wants to hear. It can turn an organization upside down. we think, and our practice has shown in responding to incidents and other aspects of providing counsel to our clients, that there are many things we can do to help clients to be in the best position should they get these dreaded words, should they hear them. One of them is understanding the threats. So let me take you back to kind of where we were. Most of you have heard the good old saying by Willie Sutton, asked about why he robs banks, and that's because that's where the money is. Well, in the age where we find ourselves, cyber criminals have found that banks aren't the only place where the money is when they can compromise the confidentiality, integrity, or availability of information and systems. And certainly in the healthcare context, cyber criminals have found many ways to monetize data. One of them, Chris mentioned, by ransomware, basically by holding it hostage. Other ways by taking key data, in particular Social Security numbers, and providing access, and selling it through the black market so that individuals can monetize that by opening various accounts and other forms of identity theft. But monetizing data is not the only thing that cyber criminals and cyber actors are doing. Another thing is they're committing destructive attacks. Some of you may recognize that individual. Whether he can use a computer or not, certainly he is the leader of a nation state and can command the energies and talents of countless numbers of individuals to perform attacks on behalf of his government. The one most noted is in the past couple of years is by this country, North Korea, on a media company. And what was important to know about that attack is that it occurred over a short period of time in which it made thousands of computers, basically turned them into bricks. And so a company that was high-tech was in a matter of minutes turned into a company where people were writing with paper and pencil to communicate until they could get their systems back up. So it's important not only to think about threat actors that may be out there focusing on your organizations that are thinking about how to monetize your information, but also how to destroy your information systems. In addition, if you talk to anyone in the information security space or information technology, they'll tell you basically if you put garbage into a program, you're going to get garbage out. But there's a corollary to that in the cybersecurity world, which is basically you can put in good information, good programming, good processes, and still get garbage out, because cyber actors are now also threatening the integrity of information. So in the healthcare space, this is obviously of life and death importance, because it could mean taking and corrupting information that could be used or needs to be used to identify patients, their procedures, the medications that they need for their health and well-being, etc. And this slide and then the following one is basically to highlight a couple points. One, we often think of hackers as people who are highly technically proficient, who can write their own code and are we thinking of them as geniuses in a kind of a separate and apart. But this particular hack that occurred in a hospital in 2009, or excuse me, this particular slide actually is about the dangers of not paying attention to cybersecurity. And what's important about this particular slide is that it didn't come from a person who's very skilled in the cybersecurity space. It came from an actuary in a report that was written 40-plus years ago in 1976. Donald Scantlebury was an accountant for the government, for the GAO and Government Accountability Office. And the point here is that oftentimes we can talk about and we can foresee and we can predict that there are going to be issues in cybersecurity But the fact is, if we don't act on them, we wind up dealing with the vulnerabilities and having to deal with the impact and the consequences. I oftentimes, in my practice and many of my partners, find that this principle is oftentimes one of the difficulties for organizations to deal with, especially in the healthcare arena. And so this cyber incident is what I was referring to a moment ago. It was performed by an individual who was a contract security guard for a hospital. And essentially what he did is he developed code that could do a couple things. One, it could transmit, it could affect medical examination, diagnoses, treatments, etc. And it also could control the air conditioning system. Now, given that this was, any hospital where you can control the AC system, which is not technically a medical device but is part of the Internet of Things, you can affect patient well-being. And this was in Texas, so it was particularly a dangerous action that was committed by this person who was not thought of by anyone other than themselves as a cybersecurity genius, a hacking genius. So this slide figure here is to highlight another important aspect of cybersecurity in healthcare, and that is, in addition to the FDA, ICS-CERT, which is part of the federal government, part of the Department of Homeland Security, has seen the number of vulnerabilities to medical devices that have been reported to it through, for coordinated disclosure, increased dramatically over the last several years. In 2009, there were 0 reported vulnerabilities, and you can see almost 500 in 2015. We work with clients who make medical devices and may have vulnerabilities reported about their medical devices, and help them to deal with the vulnerabilities and to make sure that they are going to address the vulnerabilities in a way that's going to be conducive to patient care as well as patient needs. So I want to spend the next couple minutes, which is basically what I have, talking about critical issues as I see them and as our practice has shown in the area of healthcare data cybersecurity. And so here we go. So this is just a slide to point out that in addition to the general economies we think about, making healthcare more available, being able to have information follow patients and the like, the healthcare space is in the context of an overall economy that is certainly going digital to the tune of about, as some people estimate, in the next 10 years, $11.1 trillion a year. Now, with those benefits, obviously come the difficulties that we confront in the cybersecurity arena. And what many of my our clients in the healthcare space often want to know is, how much compliance, how much cybersecurity, how much HIPAA adherence is enough? And that's a difficult question because, obviously, as you know, HIPAA provides certain flexibility. As you know, the privacy rule really isn't a cybersecurity rule. It deals with when and how covered entities may use and disclose information, protected health information, but it's not a cybersecurity rule. And then you have the cybersecurity rules, the security rule, which includes administrative, technical, and physical safeguards, as well as the breach notification rule. Now, you can follow those to a T, and it won't protect you from having a cybersecurity event. It requires, and I'll just go back to risk. We are working with our clients over and over again to deal with the idea of risk analysis, the idea that risk analysis done in 2017 is not going to be the same risk assessment you'll have at the end of the year or next year. It's having an ongoing understanding of the risks you face and how you're going to deal with them on an ongoing basis. Another point I'd like to highlight is that to deal with cybersecurity, you have to have a constant understanding of who your insiders are, what they're doing, and how they're interacting with your systems. You also need to understand and be on top of behaviors of your business associates, which you would do as an administrative safeguard, and also other third parties. Another thing I can't underscore enough is the importance of having robust incident response capacity, being ready for the inevitable. Now, obviously, we're not able to get into details of all the points I'm making now, but we will have subsequent webinars and other events to be able to get into some of the specifics. But it's important to have that team in place beforehand. For example, if you're a covered entity and you have a large number of business associates or other agreements, it's important to know who those are at the beginning before you have an event. In the time of responding to an event, it's a very difficult task to be able to go through those agreements and figure out what your notification requirements, who may have to notify you, and the other web of different contractual requirements, not to mention the regulatory requirements that you may face. And this is just to highlight the different liability costs that can come from countless sources. You know, if you have a cybersecurity incident, as you know, HHS-OCR, but class action lawsuits, state agency investigations, enforcement actions, and so on and so forth. And with that, I want to turn over to my partner, Laura Hammergren, who will talk to you about investigations and enforcement actions.
Thank you, Marcus. As mentioned, I'm Laura Hammergren, a partner in Mayor Brown's litigation group in Chicago, and today I'm going to be focusing mostly on recent HIPAA enforcement actions. As 2016 was really a big year for those actions. The lessons learned, developments we may see now that there is a new administration, and best practices, if I can squeeze it all in before 1 o'clock. This might, compared to the presentations we just heard, this might seem a little bit of a blast from the past, because a lot of the enforcement actions to date are still based very much on physical actions. But, you know, laptops being stolen, people taking hard copy records outside of a company. But as Marcus just talked about, more and more the physical and digital worlds are being linked. And so I think we can still apply a lot of these lessons going forward. And I think the next couple of years we'll have even more developments in this area. Looking at this first slide, 2016 was a record-breaking year in HIPAA enforcement resolution agreements and monetary penalties. At the end of 2016, the Office of Civil Rights of the Department of Human and Health and Services, I'll talk about those as OCR or HHS, that office logged over $20 million in fines for HIPAA violations from 15 enforcement actions with monetary penalties. This is really a stark contrast. As in 2015, it was just $6 million and just 6 resolution agreements. And the previous annual record was only $7.4 million in 2014. So we're really seeing a rise in enforcement actions for HIPAA violations. And we're also seeing the fines increasing, where previously, you know, a high fine was lower than $1 million, and now a high fine is $2 million or more. Reasons for the increased activity may just include, you know, increased reliance and integration of technology into the healthcare field. And then we have more data breaches, more sophistication in the data breaches, and we've also seen the number of complaints from external parties rise significantly. So it seems like it's a trend that's only going to keep going up. And here on this slide, we'll talk a little bit about some of these in more detail, but you can see there were some pretty significant settlements last year, and we see it across all types of companies, all across the country. No organization, no type of breach is really immune from potential data breach activities or hacking, and then the potential resulting enforcement actions. We're also seeing non-monetary penalties increasingly come into the fold. Prison sentences, a few have now been issued based on HIPAA violations. The most well-known instance is a former employee of a Texas hospital who was alleged to have accessed PHI with the intention of selling it for personal gain, with an 18-month jail sentence. Although it seems like a long time, but that's considerably less than the 10-year maximum term that HIPAA provides for. We're also seeing doctors and nurses lose their licenses, and this can be a way that employees who do some sort of intentional action may be pursued, even if it's a very small breach and a regulator might not be interested in pursuing it. There are potential ways that those employees can still be penalized. We're also seeing state attorney generals who have authority under the HITECH Act to also issue fines, and we're seeing an increasing number of state attorney generals taking action as well. 2016 was also an interesting year. It was only the second time that the OCR pursued a civil monetary penalty in court. And we saw them take a home health care agency in front of an administrative law judge, and eventually that agency was imposed a $200,000 fine, which isn't a significant fine, but it was significant because the court confirmed all of the aggravating factors that that OCR had proposed, and it's speculated upon that those might not all have been upheld if there was a settlement. So there is considerations when under an enforcement activity. To hit on some of the trends we're seeing from enforcement activity, the failure to implement policies and procedures is an often cited issue. In March 2016, we saw one of the largest settlements with HHS, where a medical research institute paid $3.9 million in addition to having to institute a corrective action plan. And in that case, a laptop was stolen from a car, which contained the PHI of many research participants, and the laptop was password protected but not encrypted. And HHS alleged that the Research Institute's policies did not address safeguarding electronic PHI that could be removed from the facility. And we're seeing that in many, many cases. And so, you know, it's just part of today's world that employees are allowed to work remotely, but there really do need to be stringent policies in place surrounding those issues. Another trend is having policies and procedures, but then not following them. In 2016, we saw a settlement between HHS and a mental health organization in Alaska, where it was alleged the organization failed to patch their systems and continued to run outdated and unsupported software, and then a pretty unsophisticated malware data breach happened. And so the HHS officials said that they had found that the organization had adopted HIPAA policies, but that back in 2005, and then had failed to actually update their software in line with those policies, and failed to update the policies. So instituting policies is important, but will only get you so far. The failure to obtain a business associate agreement or go through proper protocols in executing agreements are more and more coming up, and a lot of times it might not be the basis for the enforcement action, but will be kind of a side issue that that is gaining a lot of traction in HHS settlements. This year, a Minnesota hospital paid a $1.55 million settlement to HHS, settling charges that it had violated HIPAA by failing to enter into a business associate agreement with one of its contractors. Again, involved was a laptop stolen from the vehicle of a North Memorial vendor, and it contained a lot of PHI, and it was discovered that there was not sufficient business associate agreements in place. And so there's, you know, so many issues with that, that HHS got a pretty significant settlement. And then we have the failure to conduct risk analysis and conducting those risk analysis but failing to address vulnerabilities. HHS is often citing risk analysis and their sufficiency often when settling with companies, and so again, that's another huge feature to continue to look at. And so in the case of any companies that are looking to, you know, shore up their policies, these areas are kind of good ones to start with. They're broad, but each one has really been pointed to as increasing people's vulnerability to cyber attacks and potential data breaches, and so should be looked at carefully. Very briefly, we'll just to touch on HIPAA enforcement under the new administration. I think right now commentators are speculating that, especially with the appointment of a new director who was working in the Department of Justice's Civil Rights Division, that there probably won't be a lot of change. Privacy and security are huge issues to people, and enforcement actions and increasing number of investigations brings money into the government. And so although the administration has given some indication that regulators and regulations are not a priority for them, this privacy regulations may be an exception to that. I guess we'll have to see. And just to click through some of my slides quickly, I just wanted to get kind of to the best practices for companies under investigation. And it's really having a plan in place for when the regulators come knocking, and then following those plans. And our PowerPoint will be made available if anyone would like to ponder enforcement actions and having a plan in place in more detail. But just having a set team that's ready to go and has a plan, and quickly trying to learn the scope and the nature of the allegations in any government investigation are really going to be the key areas to start with and continue with. I'll pass it back to Marcus to conclude things.
Thank you, Laura. I want to thank each and every one of you for joining today's presentation. We hope that the information shared today was useful. As I mentioned earlier, should you have any questions related to today's topics, please email them to Jeremy Fegley, J-F-E-G-L-E-Y, @mayorbrown.com, and your questions will be promptly forwarded to one of us, and we look forward to getting back to you as soon as possible. Thank you again for your participation, and have a great day.